Access Minnesota. Issues that matter to you. Access Minnesota brings you the newsmakers and the stories that shape our everyday lives, with analysis from University of Minnesota faculty experts. Now, here's Jim Dubois.
While the scientific community continues to sound the alarm on climate change, partisan gridlock in Congress is holding up action on environmental legislation. But as lawmakers have failed to act, an increasing volume of climate-related matters are being resolved in U.S. courts. Currently, there are over 700 cases involving climate change issues. This month on Access Minnesota, we're joined by University of Minnesota law professor Hari Osofsky, co-author of a new book titled Climate Change Litigation: Regulatory Pathways to Cleaner Energy. We'll discuss how litigation is changing corporate behavior and which court cases have made the biggest impact on U.S. policy related to climate change. Hari Osofsky is a professor in the University of Minnesota School of Law. She is also the co-author of the new book titled Climate Change Litigation: Regulatory Pathways to Cleaner Energy. Professor Osofsky, welcome to Access Minnesota.
Thank you so much for having me. It's a pleasure.
Do we have an idea of how many lawsuits are currently going forth concerning climate change?
So over the past couple decades, there have been over 700 suits. After the Supreme Court decision in Massachusetts v. EPA, which is the first big Supreme Court case on climate change that serves as the basis for most of the regulation that the Obama administration's doing on greenhouse gas emissions. Since that case, there was a real explosion of litigation. Just to sort of contrast us, Australia, which is the country that has the second most in the world, has well under 100. So, we have many times more than any country in the world.
What are the environmental issues that climate change litigation generally addresses?
So climate change litigation focuses on climate change mitigation largely. So climate change mitigation is where you're trying to control the emissions of greenhouse gases so that you limit the impacts that happen from climate change. There is, however, an emerging set of cases focusing on adaptation, which is how we respond to the changes that are already happening and going to happen in the future, and take measures to be protective against them. However, it's important, I think, to think about these cases in their broader context, which is that climate change is an environmental problem, but it's connected to so many different types of law and so many different parts of our society, because we really live in a carbon economy. And so when you're thinking about climate change litigation, there's the core cases that are really fighting over what we do about climate change, how we regulate climate change or what, corporations are doing. But there's also all sorts of other cases that may or may not even mention climate change directly, but that relate to the problem of climate change.
When did the Supreme Court start hearing cases involving climate change?
The first Supreme Court case on climate change was the case of Massachusetts v. EPA, which was decided in 2007. Some people have referred to this as the most important environmental case of the decade. It has served as the basis for the Obama administration's regulation of greenhouse gas emissions under the Clean Air Act, which is our broad environmental law that regulates, was originally created for to address what's known as ambient air pollution. We typically think of it as smog. But the Supreme Court said that its definition of pollution was broad enough that it could apply to greenhouse gases as well. And so we're currently regulating both car emissions and power plant emissions as a result, relying on that decision.
What are some of the most significant cases involving climate change?
So in addition to Massachusetts v. EPA, which is certainly the most important in the United States, there have been two other cases that have reached the Supreme Court. AEP versus Connecticut dealt with whether sort of these major sort of corporate emitters were causing a public nuisance by their emissions. The Supreme Court didn't really reach the substantive question because they decided that the case was displaced, the claim was displaced by the fact that the EPA could regulate climate change under the Clean Air Act. So they basically said, since you have the statutory pathway, we're not going to allow this common law nuisance pathway. The other major Supreme Court case, Utility Air Regulatory Group versus EPA, dealt with a challenge to the regulations that the Obama administration has promulgated under the Clean Air Act. And that case was one in which the Supreme Court mostly upheld what the EPA was doing, but struck down part of it. And so, for the most part, the Obama administration is still able to regulate the emissions that it wants to. It focused only on an aspect of the power plant regulation, so the Supreme Court did not grant certiorari on the vehicle regulation. And then, as I said, some of the most interesting emerging cases are happening in the adaptation realm. So we're there, for example, was some really interesting petition brought in to the New York Public Service Commission, which is the entity that regulates electricity in New York, in the aftermath of Superstorm Sandy, saying essentially that they needed to do storm hardening and preparedness so that to protect the grid for future storms. There was a really interesting case in New Jersey brought that involved the takings clause of the Fifth Amendment of the Constitution. So that's a clause that says that if you if government takes property from people, they have to do it for a public purpose and they have to pay compensation. And so this was a project that involved protective sand dunes. And so it was taking a little bit of people's property to build the protective sand dunes. There was no question the property had been taken. The question was, how much compensation should they get? And what the Supreme Court said, the New Jersey Supreme Court said was that when you do the compensation analysis, you have to not just consider whether, the value of the property, but also how much the property is being helped by the protective sand dunes. And so they ended up reducing the compensation to $1 because of the protective sand dunes. So there's an interesting set of cases there. And then finally, the set of cases that are not necessarily high profile in sort of an individual basis, but that comprise the vast majority of climate change litigation are cases involving environmental review, often in the context of coal-fired power plants, essentially saying that climate change needs to be taken into account in environmental review. And those have had a really significant impact in terms of making it more expensive for coal companies, in the sense that they're having to deal with the expense of a legal challenge, the delays, potential financing issues, et cetera.
There's not a single person or company that can be held responsible for the changing climate, and the effects of climate change are usually identified at a planetary level. Because of this, how difficult is it for plaintiffs to prove they have standing?
So this has been an issue in these cases from the start. And this is where the Supreme Court's decision in Massachusetts v. EPA solved the issue for one set of plaintiffs, but not for others. So what the Supreme Court said in Massachusetts v. EPA was that Massachusetts had standing, that they had enough of an interest. They were currently suffering harms from climate change due to their coastal impacts, and that they were going to suffer more severe harms in the future. But they also talked in that opinion about the particular sovereign interest that Massachusetts had in addressing sort of these problems in their borders. So what the Supreme Court didn't reach in Massachusetts v. EPA, and none of the 3 Supreme Court decisions since then have reached, is the question of whether a non-governmental plaintiff has standing. And the lower courts have split on this question.
The science involving climate change is often difficult to interpret. When Access Minnesota returns, U of M law professor Hari Osofsky discusses how the courts are comprehending climate science.
Access Minnesota will return after these messages. You're watching Access Minnesota. Here's Jim Dubois.
Now back to our discussion on climate change litigation with University of Minnesota law professor Hari Osofsky. How well have the courts interpreted the science of climate change?
Climate change science is complicated. And that plays out in a variety of ways in the litigation over it. So some judges, particularly, for example, Justice Scalia, have expressed a great deal of concern about whether that courts are really the right bodies to address this because of how complicated the science is. So, for example, in the oral argument of Massachusetts v. EPA, when he accidentally made a mistake in talking about the troposphere versus the stratosphere, he was sort of like, troposphere, stratosphere, you know, I'm not a scientist. This is why I don't want to be talking about this. You also see a sort of varying of how climate science is being talked about in the courts, both based on what administration appointed judges and based on what's going on in this sort of broader political backdrop. So even though our judges are independent, neutral adjudicators, they don't live in a bubble. And so, especially because of the politicization of the appointment process, one of the things that came out in the interviews that we did for the book is that you see differences, for example, in Clinton and Bush appointees and how they interact with these cases and how they interact with the climate change science. So it's not an easy thing to deal with, but it's an important problem. And so belongs in the courts as a way of sort of trying to deal with conflicts over how we should regulate sort of what in Massachusetts v. EPA was even acknowledged by the dissent as maybe the most pressing problem facing humanity.
Has climate change litigation made a significant impact on corporate behavior in the U.S.?
Well, yes and no. You know, on the one hand, clearly there are still corporations that are significantly emitting greenhouse gases. But we've seen a number of changes, and sort of the interviewing we've done has also revealed sort of ways in which it impacts corporate practice. So one of the things you've seen as a consequence of, I think, climate change litigation is that corporations recognize often that they have to deal with this. So you see a lot of corporations, not just energy corporations, but sort of major corporations thinking more, I think, than they were before the litigation took place about how they need to deal with both their emissions and the emissions in the products that they buy, and the ways in which adaptation may sort of affect their business. So it's being taken into account more in terms of business risk models, and you know, and corporations are thinking about it. You've seen, for example, in the major law firms, a climate practice and advising that you haven't seen before, similarly in environmental NGOs. So I think that one of the important things that climate change litigation has done is it's really raised awareness across the board for corporations. Now, when you talk about the corporations that are most targeted by climate change litigation, namely coal companies, there you see the most significant impacts. It's hard in some ways to separate out the climate change litigation from all of the other types of litigation happening around coal, and the fact that natural gas has become cheaper, which has really hurt the market for coal, and the sort of regulatory environment for coal. But that trio of things, that combination of the changing sort of markets, the litigation and the regulation, has made it sort of a much tougher environment for coal. So to the extent that coal is the source of energy that's sort of the worst from a climate change perspective, this litigation, together with other strategies, has played an important role, I think, in helping the transition away from coal.
When Access Minnesota returns, we'll hear about several climate change lawsuits in Minnesota.
Access Minnesota will return after these messages. You're watching Access Minnesota. Here's Jim Dubois.
Back to our discussion with U of M law professor Hari Osofsky on current court cases in Minnesota concerning climate change. Tell us about some of the significant climate change cases here in Minnesota. What issues have been addressed in those cases?
Minnesota is actively involved in sort of the national dialogue about climate change. So, for example, it's one of the group of states that signed a sort of letter supporting the Obama administration's Clean Power Plan. So the sort of controversial efforts that the Obama administration's making, with the final rules to come out this summer to regulate existing power plant emissions. You know, the Minnesota had some critiques for the EPA. It didn't think it was a perfect law, but it's in the group of the states that's generally supportive of it, and isn't going to have any major problems complying with it.
The Dormant Commerce Clause comes up a lot in environmental law. Can you explain exactly what that is and why it is used in these cases?
So the Dormant Commerce Clause is an interpretation of the Commerce Clause of the Constitution, which says that states can't pass laws that interfere with interstate commerce. Now, this is a complicated thing as our economy, and in particular our energy economy, gets more intertwined, right? So when states are producing power, they're not just producing it from generators in their own states. And so what has happened is that in 3 different states, in California, in Colorado, and in Minnesota, there have been challenges to different aspects of either climate change or renewable energy laws. The Minnesota one in particular deals with a challenge by North Dakota and the lignite coal industry representatives and multi-state electric cooperatives to a provision of Minnesota's Next Generation Energy Act, which is a broader law that sets Minnesota's renewable energy goals. And in particular, the provision that's being sort of fought over is that the law requires carbon dioxide offsets for importation of new out-of-state coal-fired power plants. And so essentially, North Dakota is claiming that that requirement is interfering with interstate commerce, that it's influencing North Dakota. And so, as I mentioned at another point in our conversation, the district court actually has found that there's a Dormant Commerce Clause problem, but it's under appeal. And all of the other cases that have involved these kinds of Dormant Commerce Clause challenges have been ultimately unsuccessful, so there's a reasonable chance that the Minnesota one will be as well.
Have climate and environmental issues become more politicized in recent years? If you look back, President Nixon, a Republican, authorized the Environmental Protection Agency. How have things changed so dramatically in 45 years where now there seems to be a growing resistance against regulations dealing with the environment and climate change?
So Jackie and I, in addition to having this new book out on climate change litigation, this book actually inspired us to begin to think about energy partisanship and how do we act constructively in a partisan environment. By constructively, I don't mean one side wins. I mean actually get people to work together in a constructive way. And so we have an article coming out in the Emory Law Journal and are on our way to doing a book on this issue. And you know, one of the things that's very clear is that you're absolutely right. Partisanship has gotten worse across the board in the last 20 years and is particularly worse on environmental issues. And climate change, some have referred to it as now being in that category like taxes and gun control, which really define what it means to be a Republican or a Democrat. I think that one of the important ways out is to, so there's a whole stream of social science research that suggests what may be obvious to those who watch the sort of news coverage of this and the public dialogue about this, which is that just giving people more information isn't the solution to bipartisanship kumbaya moments, right? People really tend to listen to people that they trust and tend to be embedded in their own worldviews. And so one of the things that Jackie and I argue, we've looked at both substantive and structural ways you can reframe the issue to try to get people to cooperate more, is that there are things that Republicans and Democrats actually do agree upon, and things that relate to the problem of climate change. And the two that we've found that have been most effective in getting bipartisan action have been the economy and disaster resiliency. So it turns out that though there's a split between Republicans and Democrats on lots and lots of things, one thing that everybody agrees on is that having a sort of well-functioning economy is good. People like jobs. And so when you can get win-wins, where taking action on climate change, whether you call it that or not, is actually good for jobs, you tend to see bipartisan action. So for example, you have a lot of, in states that have big and growing wind industries, the Republican governors and senators are behind their wind industries, right? Similarly, you know, the Tesla story is a particularly good one on this partisanship front, right? Where you know, initially, Tesla was sort of vilified like Solyndra, right? Back at the time of the Solyndra scandal, you had Palin and Romney saying how terrible Tesla was. But then, Tesla paid back his loan really fast. and was suddenly doing all this really interesting stuff with batteries and wanted to build a battery factory. And all of a sudden you saw Republican politicians and even people on Fox News saying that Tesla was something worth supporting. Similarly, around disaster resiliency, Superstorm Sandy provided a major impetus for bipartisan efforts to make us more resilient against storms. Nobody likes the power to go out. Whether you're a Republican or a Democrat, you want to be able to turn on the lights. You want to be able to plug in your iPad, right? So that provides another way in. Again, you might not want to call it climate change adaptation, though adaptation is in general less controversial than mitigation, but that's another place where people are willing to work constructively together on solving that problem, which then ends up being adaptation.
Court cases can drag on for years, particularly when they involve corporations with significant legal resources. Do you have concern that environmental lawsuits cannot change harmful behavior and practices fast enough?
Well, I'm in general concerned that we're not addressing this problem fast enough. I mean, there's a report that seems to come out on a weekly basis reinforcing the story, which is that we are not reducing greenhouse gas emissions at the rate that scientists say are needed. So for anyone who's not an out-and-out climate change skeptic, if you think there's any risk that humans are causing this problem, the consensus science says we're not solving it fast enough. And nothing on the table is solving it fast enough, just to be clear. So we have this big climate change conference coming up in Paris this December. Minnesota's going to be sending a delegation there. You know, and it's a big moment in the sense that there's supposed to be an agreement, sort of the first effort at a universal agreement around emissions reductions. But it looks likely that that's going to be mostly around voluntary reductions, and none of the reductions on the table are anywhere near what scientists say are needed to control this problem. So in that environment, litigation is clearly not going to solve climate change. But what litigation does, I think, is two things. One is that it, I think, has been playing a constructive role in getting more action than there would have been otherwise. So when you look at, particularly in the United States, the really important role that litigation's played as serving as undergirding our regulation over climate change, it's causing us to do emissions reductions that, even if they're not enough, are better than would have happened without it. But the other thing that litigation, I think, plays an important social role in doing is serving as a place where a diverse set of interests can come together and have a dialogue about these issues. It may not always be, you know, a happy hand-holding dialogue, but entities from different levels of government, corporations, the NGO community, come together in sort of a respected public space in order to really sort of figure out pathways forward. And so to that extent, I think litigation also plays an important role. One of, I think, the more interesting cases involves San Bernardino County. So not a city, but another local government entity. San Bernardino, for those of you in Minnesota who aren't that familiar with it, is a county in California that has been one of the fastest growing in the United States. And it got sued back in the late 2000s by both California and by some NGOs in separate suits for not including climate change in its general plan, because it was proposing tons of growth that was clearly going to have a major emissions impact, and didn't mention climate change despite comments asking it to do so. And the really interesting thing isn't in the case itself, but what happens from it, which is not only does San Bernardino County settle with California, but then Attorney General, now Governor Brown, went around the state to other recalcitrant counties saying, you know what, if you don't start doing this, we're going to sue you too. And so then you say, okay, and the reason I mention localities, you say, but they're really, really small. Each city matters so little on a global scale, particularly if you take really little cities. But here's the thing. The predictions are that about 70% of greenhouse gas emissions come from cities. And in the United States, 82% of our population live in cities. So local land use planning decisions end up playing an incredibly important role in whether we're going to address this problem of climate change adequately. And cities in the aggregate matter a lot. And so I'd say that about cities, and I'd say that about the litigation, which is that even though each of these things are individually small, in the aggregate they can really matter a lot.
Hari Osofsky is a professor in the University of Minnesota School of Law. She is the co-author of a book titled Climate Change Litigation, Regulatory Pathways to Cleaner Energy. Professor Osofsky, thanks so much for joining us on Access Minnesota.
Thank you so much for having me. It's been a pleasure.
That's all for this month's edition of Access Minnesota. We'll see you again next month. Thanks for watching.
Access Minnesota. Issues that matter to you. Join us again next week as we bring you the newsmakers and stories that shape our everyday lives. Access Minnesota is produced by the Minnesota Broadcasters Association in cooperation with the University of Minnesota's College of Liberal Arts.